data regulation, health, and health-ish data practices under the microscope. We've got people signing on, trickling in. So we'll go through a few housekeeping items first. We are recording today's program. During the presentation, all participants will remain in listen-only mode. We will be circulating the materials as well as a recording in the days following the session. If you experience any technical difficulties, please send a message via the Q&A panel, which is located in the lower right of your screen, and ask for assistance from the host. This will be picked up by our IT support team. We have scheduled time to answer questions at the end of the session. Please use the Q&A function and select all panelists to ask a question directly to our team. If we are unable to answer your questions due to time constraints, we will follow up with you shortly afterwards. Next slide, please. My name is Kyle Fath, and I'm a partner in Squire's data privacy, cybersecurity, and digital assets practice based in our Los Angeles office. I'm a privacy and technology transactions lawyer with a broad client base and experience in a variety of areas, most notably ad tech and digital advertising, digital publishing, retail media, consumer packaged goods, health tech, and so on. I'll pass it on to my colleagues, Bola and Giselle, to introduce themselves, but I'd like to extend a warm welcome to Bola. Today is actually her first day with the firm, so let's give her a virtual round of applause and warm welcome.
Thank you, Kyle. Hi, everyone. My name is Oluwalade Shinowo. I go by Bola for short. I'm actually, excited that today's my first day, but I am coming from the in-house counsel realm, federal government sector as well, with experience in healthcare privacy, product counseling, in a variety just like health tech organizations. I want to say for nearly a decade now. I'm really happy to be joining at a time like this where privacy legislation is so apparent and on the rise. And I'm looking forward to really helping our clients understand what their obligations are when it comes to really comprehensive laws like this. My health, my data, when we get into it, you'll be really surprised at some of the things. And I just, hope you all enjoy the presentation.
Welcome, Bola. Hi, everyone. My name is Giselle Tomenbang. I'm an associate in our global data practice in the Los Angeles office. I work with Kyle and Bola on healthcare privacy issues. Prior to joining Squire, I was with the California Attorney General's office, and before that, I was with OCR. And so I look forward to presenting to you today. Hopefully, you find information helpful to your practice.
So why are we here? We could certainly start this story in a lot of places, but for purposes of brevity, we'll start on June 24th, 2022. That's the day that the Supreme Court struck down Roe v. Wade and its decades of precedent providing for abortion rights. While this decision did not make abortion illegal nationwide, it did cause many states with Republican governors and attorneys general to invoke what are called trigger laws that were designed to go into effect upon the fall of Roe. Other states resumed enforcement of laws that had been put into effect after the Roe decision. So in response, Democratic states have been enacting several protective measures. Attorney General Bob Ferguson of Washington decided to, as part of his way to protect individuals, champion a health data privacy law at the beginning of the 2023 legislative session earlier this year. That's the law we're going to talk about today, the Washington's My Health, My Data Act. Recognizing that our federal health privacy law, Hippa, does not adequately protect all health data, the stated intent of My Health, My Data Act is to fill the gap left by Hippa. Hippa protects information collected from healthcare providers and other covered entities like pharmacies, but does not, for example, prevent a state official from obtaining data from online services that would, for example, indicate a woman has had an abortion or has traveled to a different state to have one, such as geolocation data, purchase data, internet and app usage history, and so on. But in today's connected world, we leave a pretty substantial footprint of what we've done, where we've been, what we've bought, and so on. And HIPAA doesn't cover that sort of data. My Health, My Data and other consumer privacy laws do. The law passed by the legislature was passed by the legislature pretty quickly, notably with the private right of action that we're going to talk a lot about more today. Private rights of action have historically been an impediment to the passage of consumer privacy laws. Given the political environment this year, however, and the intent of the bill, it was not much of a surprise, at least to the privacy community, that the law ended up passing, even in view of the private right of action. We look forward to discussing more about this law and consumer health data regulation more broadly with you today. We can move on to the next slide, please.
All right, so I'm going to swiftly walk us through our roadmap of what we'll be covering today. As Kyle mentioned, we're going to set the stage with the health and health-ish data landscape, really level setting on with Hippa as like our federal standard for PHI, and then cover some additional state laws that touch on health-related data. And then we'll talk about what we've seen from a litigation and enforcement lens. And then we'll spend a majority of the time really digging into the law, Washington's My Health, My Data Act, some of the key definitions on, who is a consumer, what is consumer health data, and then we'll transition into organizational requirements and obligations, and then what are some of the respective consumer rights, and then have a really good conversation on consent and authorization requirements. Then we'll wrap up with just some of our key takeaways and how this should apply to organizations moving forward. I do want to point out that, this law is, pretty broad and comprehensive. So, we've done our best to really detail what we feel are some of the most important requirements and issues. But I also just want to say we did include some explanatory notes and detailed comparison charts in the appendix of this presentation. So that will be made available later. Next slide, please. All right, so just, a quick note, Kyle did a really great job about setting the stage on, why we're here and why this law is being enacted. The purpose, is meant to do, a lot of things with respect to abortion rights, as well as, Washington's want for comprehensive privacy legislation. But we do want to make it clear that, our commentary here today should not be viewed as a lack of support for individuals, and their right to receive healthcare services and, their privacy rights as it relates to, a lot of, the things that this act aims to protect in relation to, reproductive and sexual health, gender affirming rights. Our purpose in today's discussion is really meant to focus on the various compliance challenges that organizations will need to follow upon its enactment next year, and how we can be of a resource to really help you comply. Next slide, please. All right, so let's jump right into it. Hippa, as in comparison to My Health, My Data, let's level set on where we started in 1996 and how we're going to be transitioning to My Health, My Data in 2024. I thought this table did a really nice job of conveying some of the high level points that Hippa has in comparison to this new law. I'm not going to spend a ton of time on defining the new terms on the far right of the column in the My Health, My Data, because we'll be dissecting those, as I stated in the later slides. But what I really want to set up is how Hippa applies in comparison to the new law, and just start focusing our attention on those distinctions. So with row one, who's covered, for the most part, HIPAA is applying to our covered entities, and then their business associates, their third-party business associates. That's also going to be including their sub-business associates. Covered entities, those are our providers. So thinking of, your PCP or pharmacists, the Quest Diagnostics, emergency care centers. That also includes your health plan insurers, as well as the clearing houses. And, those are the entities that are working with the health insurance company to make sure that the PHI is, properly getting transmitted. And we'll see as we really dive into the act, who's covered is a lot broader than you might expect in comparison to HIPAA. You might be surprised at what type of entities or, what type of person is in scope. And so, and we'll actually need to comply. And so we'll definitely cover that. Jumping on to row 2, what type of data is covered? So obviously protected health information, we know that to be individually identifiable information that is held or transmitted by the covered entity or the business associate, and it's relating to your past, present, future medical or physical or mental health or condition. In comparison to my health, my data, that's consumer health data. And so I do want to point out here that, PHI, the data that we historically known to be governed by Hipaa is one of the exemptions under the law. And, for illustration here, I'll kind of talk about that, but want to note that there are those nuances for covered entities and business associates who may have covered consumer health data, and especially when it's intermingled with PHI, there's a nuance there. So for illustration, um, say there's an individual who has a sleep tracker and wants to, track their sleep patterns because they're suffering from insomnia. That sleep tracker itself may not be covered by Hipaa because you have an individual who's inputting their own data in the app, and then that app itself is not sharing or receiving data from an individual's medical record. At that point, this data is likely, there's an argument that this data is considered consumer health data under my health, my data. But let's say later on that that same individual is like, hey, I want to work with my doctor, to, figure out a medical solution for my insomnia. And I want, to share this tracker share my results with the tracker with my provider. Well, now we can say that, there's an argument that this data is becoming intermingled because the physician who's a provider here is now using this sleep tracker data to help diagnose, to provide a treatment. So, there's, that strong argument that now it's PHI and it now relates to, the physical condition of the individual. And thus that sleep tracker data, held by the provider is exempted under my health, my data. So it's, really important to think about all of the nuances and the exemptions under the law so that you're, one, giving it the proper protections, but you're also, if you're an organization here, you're scoping out the appropriate exemptions. Transitioning to row 3, safeguards. Hipaa has historically, obviously, a lot of us are familiar with the Hipaa privacy and security rules that are establishing those national standards to protect PHI. In comparison, the Washington law is going to require some more prescriptive privacy requirements, as well as data security and access restriction implementation components. Then on row 4, notice, really one of my favorite themes, notice of privacy practices and privacy policies. Providers, we know they must provide the NPPs, usually on that first office visit or sometime in advance by an electronic means. And it should really tell the individual how that provider is going to be using, storing, accessing their health information, also what the individual's health privacy rights are. If you're a business associate in this space, you'll probably have a link on your homepage to your privacy policy that's really prominent, or at least should be prominent. In comparison, my health, my data does require what is being referred to as the consumer health data privacy policy. We'll get into those requirements a little bit later. So next on row 5, consent and authorization. Generally, Hipaa is permitting covered entities, business associates to use and disclose PHI as long as as long as it relates to TPO. So treatment, payment, healthcare operations. And if there's another purpose outside of this, then, use and disclosure is not generally permissible. You'll really need an individual's authorization if you want to use it for any purpose outside of that. We'll spend a nice chunk of time really carving out the consent and authorization requirements under my health, my data. We'll get into that a little bit later. On row 6, enforcement here, both HIPAA and My Health, My Data include civil penalties for noncompliance. But the huge difference that I wanted to talk about here is just that HIPAA does not have that private right of action like we'll see with this new law. What HIPAA allows is an individual's ability to file a complaint with the U.S. Department of Health and Human Services, Office for Civil Rights. That's the HIPAA Enforcement Authority. Also, OCR may conduct its own independent investigations if they're aware of noncompliance. So most notable and recent examples include the warning letters that OCR and the FTC actually sent to hospitals about online tracking pixels last December. So that's a really nice distinction there that we have. And then lastly, consumer rights. This is not anything new. We've been seeing it in a lot of the state laws. Again, HIPAA and My Health, My Data, they address consumer rights, a lot of the ones that you see enumerated here. One of the outliers that I did want to address for HIPAA is that there is no right to deletion like we do see with My Health, My Data. Mainly because of feasibility. Think about the covered entity context. Think about the health insurer who wants to assess what the insurance premium should be for a patient. Well, they'll need access to that patient's past medical history. And so, they may want to know, should this patient pay a higher premium than another premium if they're, looking for cancer related treatment, but that patient, or that individual has a history of tobacco use? Well, that patient is probably a higher risk. So they'll want to give a higher premium to that patient. So, deletion is not necessarily feasible in this context, and that's why we don't historically have that right to deletion for covered entities and business associates. Next slide.
Thanks, Bola. So the landscape of U.S. laws applicable to consumer health data is a patchwork of federal and state laws. Other laws that apply to health data other than HIPAA include laws enforced by the FTC, such as the Health Breach Notification Rule in Section 5 of the FTC Act, and the omnibus state privacy laws like the ones currently in effect in California, Colorado, Connecticut, and Virginia, and that will be in effect in Utah in December. Of the state privacy laws, Colorado has the most prescriptive requirements for sensitive data, which includes consumer health data. In addition, this year, Connecticut, New York, and Nevada all pass health data privacy specific laws. There are distinct nuances between these laws between the laws listed on this slide and Washington's My Health, My Data Act. We included detailed comparison tables in the appendices at the end of this presentation, which we will circulate to registered attendees following this webinar. Before we move on, we wanted to call your attention to the health data privacy specific state laws that passed this year. First, Nevada passed a law that's similar but not identical to the Washington law. It will go into effect on March 31st, 2024. It differs from the Washington law in that it doesn't have a private right of action, and the definition for consumer health data is a little narrower than the Washington definition. Second, the Connecticut legislature amended Connecticut's omnibus privacy law to include a definition for consumer health data as one of the data elements that's considered to be sensitive data. This means that as of July 1st of this year, there are now more stringent notice and consent requirements applicable to the collection, sharing, and selling of consumer health data in Connecticut. And also, unless stated otherwise, the consumer rights that applies to personal data now also apply to consumer health data in Connecticut. Finally, the state of New York amended the general business law to prohibit geofencing around healthcare facilities by anyone other than the healthcare facility for purposes related to digital advertising. So things like consumer profiling, sending ads, and inferring consumer health status. And so here are some examples of health privacy related headlines we've seen in the past couple of years. As we're all aware, earlier this year, the FTC used its authority under the FTC Act and the Health Breach Notification Rule in an enforcement action against GoodRx. In that action, the FTC alleged that GoodRx violated Section 5 of the FTC Act by misrepresenting in its privacy policies and other public-facing statements its practice of disclosing consumers' personal health information to third-party tracking technologies for digital advertising purposes. The FTC also alleged that by integrating tracking technologies in its app, GoodRx engaged in an impermissible pattern of disclosing app users' personal health information to third-party tracking technologies without the user's knowledge or affirmative express consent, which triggered GoodRx's obligations under the Health Breach Notification Rule. The action against GoodRx marks the first time the FTC used its authority under the Health Breach Notification Rule. This year alone, the FTC has pursued violations involving personal health information and other high-profile cases, like BetterHelp and Premom. Then most of us are aware of the litigation being brought under the wiretapping laws related to companies' use of pixels and cookies on websites, as well as cases being brought under similar factual bases pursuant to the Video Privacy Protection Act. Overall, countless companies have received demand letters and complaints related to these issues, and we expect this trend to continue. And then finally, the use of tracking technologies by hospitals and health systems on their websites has also been under scrutiny. As we're all aware, under Hippa, covered entities like hospitals and health systems are required to obtain the individual's authorization prior to using and disclosing PHI for marketing purposes. Disclosing information to tracking technologies in the healthcare context, and in particular when it includes PHI, is commonly a disclosure for marketing purposes. And therefore, assuming there's PHI transferred in that exchange, HIPAA regulated entities are required to obtain the individual's HIPAA compliant authorization before any disclosure occurs. OCR has issued countless guidance in the past year, advising covered entities and business associates that if they have disclosed PHI to tracking technologies in a manner that violates HIPAA, they may have also triggered their obligations under the HIPAA breach notification rule, which would require them to notify affected individuals, OCR, and in some cases the media, depending on the number of individuals that were affected in a specific jurisdiction. OCR has not publicly pursued an investigation or enforcement action related to these issues, but given the amount of guidance they've issued in the past year, it suggests that enforcement is going to be forthcoming. There's a lot to unpack when it comes to enforcement developments related to disclosing individuals' PHI and their other health-related information to third parties. We don't want to keep you here for longer than you bargained for, so I'm going to hand it over to Kyle to provide us with the key takeaways from this slide.
Yeah, thanks, Giselle. I think you really nailed it. I think the main takeaways here is there's going to be a continuing focus by the FTC and other regulators, and the plaintiffs' bar on particularly on digital advertising use cases. The use of cookies and pixels on websites and other online platforms is easy to glean from just a visit to a website. So I think this trend is not going to be unique to other laws, and it will continue under My Health, My Data. But let's speaking of My Health, My Data, let's jump into the meat of it and move on to the next slides.
Great, thanks, Kyle. So in this slide, we provide an overview of My Health, My Data. We're going to go over the broad extraterritorial scope of the law and the broad definition for consumer health data in later slides. For this slide, I want to call your attention to the geofencing prohibition in the law. So under the law, geofencing is prohibited within 2,000 feet or less around any entity providing in-person healthcare services for purposes of identifying or tracking consumers seeking healthcare services, or collecting consumer health data from consumers, sending notifications, messages, or ads to consumers related to their consumer health data or healthcare services. as we'll discuss later on, the definition for health, for what constitutes health status and healthcare services is really broad under the law, and would encompass more than data that could be collected from doctors' offices or other medical facilities. Now I'm going to hand it over to Bola to go over the other requirements of the law.
All right, thanks, Giselle. Again, we will spend a lot of time on, these draconian consent and authorization requirements. The law is placing a strong emphasis on what is necessary to have valid consent and authorization. Kyle and I will discuss that a bit later. The effective dates. This law for regulated entities, they're going to need to start complying the end of March of next year. Small businesses, as we'll define, will need to comply within by June of 2024. The only exception to these operational dates is the geofencing ban that Giselle has already spoken about, which is already effective. In this last red bucket here, private right of action, AG enforcement, I alluded to it a bit when I was covering the HIPAA comparison slides, but now is when we're really seeing, the first state privacy law with a broad consumer's private right of action, with the exception of CCPA, which, already offers it, but even there, it's, limited to breaches within an organization. My Health, My Data is really different here because the private right of action is a bit more expansive, where basically any violation under the act, is considered an unfair or deceptive act, and therefore a consumer can bring suit. And I think that, if this was just being enforced by the AG's office, we see them really use their discretion to, go after organizations that are, purposely or negligently, bringing harm or creating harm. But, this being a private right of action, there's, that monetary motivation, that we didn't have with HIPAA. So, a plaintiff consumer can recoup actual and treble damages up to 25K plus, the cost for attorney fees and other costs. There's no statutory damages, but, that's, I think enough for consumers to be on the lookout for organizations to misstep. And it's also really important here that, the act does not speak of that period or that opportunity to cure that we've historically seen. So it's really going to be important, for organizations to get it right the first time. And I'll transition it back over to Giselle to walk us through the next slide.
Thanks, Bella. So on this slide, here are the entities that are covered by My Health, My Data. Regulated entities, small businesses, processors, and any other third parties must comply with the Act. Similar to privacy laws, most of the obligations of processors will be set forth in a contract, like a data processing agreement. Just an FYI, as with the other privacy laws, whether someone is a processor is not as simple as calling them your processor. Under the Act, they must be processing data on behalf of a regulated entity or a small business. If the processor is in any form determining the purpose and means for processing, then they are a regulated entity. So we just wanted to flag that for the group. I'm going to hand it back to Bola to go over the Act's definition for consumer.
All right, so who is a consumer? There's a really broad definition here. Consumer is really any natural person who is a Washington resident, or a natural person whose consumer health data is collected in Washington. And consumer in this context means a natural person who's only acting as an individual or in the household context. So we're not thinking about individuals in the employment context. So employees, business to business data, that's excluded here. What does collected in Washington really mean? Does it mean, the consumer being physically there? There's definitely an argument that that's exactly what it means. Or does it mean that data that is collected on servers located in Washington? I think there are strong arguments to deem that to deem that correct as well. It's defining collected as any type of processing. So the law is prescriptive here, and it's to buy, rent, access, retain, receive, read, or otherwise process consumer health data in any manner. So you should really be thinking about organizations should really be thinking about, is there a nexus between a consumer and the state of Washington? And a good example is that offshoring consideration for cloud service providers that have data centers within Washington. So for example, you could actually be a non-Washington resident and a non-Washington based business, but your business has a cloud server that's located in Washington. Then there's that true argument that that non-Washington resident is now a consumer under the law. So it's really important to pay attention to the nuances here that are under the law. I'm gonna take it back over to Giselle, and she'll walk us through the next part of this.
Thanks, Bella. So the Act defines consumer health data as personal information that is linked or reasonably linkable to consumer and that identifies that consumer's past, present, or future physical or mental health status. The Act provides a non-exhaustive list of data elements indicating an individual's health status. Some of the data elements that are included in the definition are defined terms in other parts of the law. And so when you're reviewing and considering what types of data might be consumer health data under the law that describes the health status, it's important to really look to the definitions of these defined terms. In addition, the list provided, again, is not exhaustive, and so conceivably the universe of what constitutes health status is broader than what's reflected in the text of the law. I'm going to hand it over to Kyle to go over these.
Yeah, so I'm going to kind of dig in on the breadth of the law, as we kind of conveyed on that slide. Looking, as Giselle said first, it's not an exhaustive list, but within the list, a lot of those enumerated aspects are further defined in the law. So you have to sort of circuitously look around to really understand the breadth. And then on top of that, I think two of the most broad aspects of at least the enumerated portions are the data identifying a consumer seeking healthcare services, and healthcare services itself is an extremely broad definition, meaning any service provided to a person to assess, measure, improve, or learn about a person's mental or physical health. It's interesting reading people's various takes on how broad this definition is. Even learn about, that could be an article regarding anything moderately related to health that someone reads. It's extremely broad. Also, this concept of inferences, which we've seen specifically called out, like in laws like Colorado, sensitive data inferences. It's also the concept here. The enumerated aspect of the law refers to basically inferences from non-health information that's used to derive health information, but certainly inferences based on health data would also be in scope because of what Giselle pointed out with the list being non-exhaustive. Next slide, please. We're just going to talk about a few examples. I think the first two, maybe three, we talked. I've introduced how consequential and applicable this is going to be to the digital advertising space. Certainly, information collected by pixels and cookies on websites and other digital platforms are ripe for falling under the definition. Getting a bit deeper into the weeds, maybe ad tech 201 for those that are familiar with impression data. Like data regarding who's clicked on the ad, or who's received bid requests in health-related ads or non-health ads on maybe health-related websites. That kind of data may also fall under the definition. Creating internal inferences and putting people into advertising segments that are interested in a medication or health service or topic. Certainly purchase history and analytics seem like low-hanging fruit. Purchase of products, purchase and consumption of online services, things like that. Restaurants and retail collect allergies and dietary information when you're ordering food. That kind of thing could conceivably be alleged to be in scope. One thing that really jumped out to me is the genetic data. If you look at that definition further, it just basically any genetic characteristic. So hair color, eye color, those things that are just sort of everyday information that somebody might provide, they're technically, arguably consumer health data. Search engine queries, generative AI prompts, their outputs. The biometric data definition is very broad. It's not necessarily limited to a health context, though I think that's the intent. But certainly with the private right of action, anything goes. I think we can move on to the next slide.
All right. So let's talk about some of the organizational obligations. We'll break, some of these down in the following slides, but this collection of tables is really just meant to give a nice overview of how, these, regulated entities, small businesses, persons, processors must comply. First up is notice with, the consumer health data privacy policy. It is going to include some really prescriptive requirements, related to the collection of consumer health data. Next, organizations are going to need to be aware of and respond to a consumer's rights that are addressed in sections 5, 6, and 9 of the Act. In this third and fourth box, consent and valid authorization, we mentioned, before about some of the strenuous requirements when you're actually collecting and sharing data or selling data. Those are prescriptive as well, but we'll get into what is, opt-in, what is valid authorization as well. We'll dissect that. So processor / vendor agreements, we'll spend a little bit of time on this. This isn't really anything new for a lot of organizations, especially if you're already complying with TCPA or VCDPA. You're going to need to ensure that you have the appropriate agreements in place or amended data processing agreements in place that address requirements for your vendors. So who have consumer health data. So we're thinking, duties of confidentiality, security requirements, data minimization that needs to be included in these contracts with your vendors. Lastly, access control, data security, straightforward there is, making sure that you're implementing the appropriate, technical organizational measures, similar requirements that you have with Hippa and other state laws, and also really ensuring that there's that access restriction with your staff who will be handling consumer health data, making sure that there's, minimum access for those who don't need access to it. Let's go into the next slide. All right, so the consumer health data privacy policy, I mentioned earlier that this is kind of one of my favorite things to do. But this is for our regulated entities and our small businesses where they must have a privacy policy that includes several disclosures related to consumer health data, the purpose of the collection, the use and the sources of that collection. And all of these requirements in the privacy policy, must be clearly and conspicuously disclosed. So we've seen that a lot with, GDPR language, CCPA language. You can't hide the ball here. It needs to be, very apparent in plain language on what these requirements are for your consumers that will be reading the policy. And there's something I wanted to cover as well here. There needs to be, if there's going to be any type of additional sharing or collection of consumer health data that was not previously mentioned in your privacy policy, then, the regulated entity, the small business, you're going to need to disclose those, additional sharing and collection practices, but you're also going to need to receive the consumer's affirmative prior consent before you can even start any deviations from what you originally stated in your privacy policy. Another big point to mention here is that, it has to be prominently published as a link on your homepage. And I know Kyle and I have had like some strong discussions here on this because, like I mentioned, I come from the in-house counsel world. So, there's, this argument that, should this be a standalone policy or can it be supplemented as a section, within your existing privacy policy? And I think that, there are business considerations, in creating a subsection in a in your current privacy policy versus creating, a standalone privacy policy for consumer health data. But there's that valid argument, and I will agree with you, Kyle, before you even jump in, that, there should be a separate and distinctly, labeled policy. But, Kyle, I'll let you jump in with your thoughts on this.
Yeah, I think there's certainly in terms of form and function, I think the clearly and conspicuously disclose, having the consumer health data privacy policy requirements sort of mixed in with the general privacy policy would seem risky. So I think the more conservative way to interpret that is at least have a standalone section. You don't necessarily need like a standalone web page. And certainly, I think one other nuance wanted to mention is like, the law does mention a link to the consumer health data privacy policy on your homepage. But like the CCPA and other laws, homepage is defined as your homepage plus other pages where personal information is collected. So basically, it's got to be on every page. Should we jump to consumer rights next?
Sure. Thanks, Kyle. So here on the screen, we have for you the list of consumer rights that are available under My Health, My Data Act. I'm going to call your attention to the rights under Section 6. So these rights are similar to the rights you'll see under the state privacy laws. For this particular set of rights under Section 6, you'll have to describe in your consumer health data privacy policy your mechanisms for receiving requests related to these particular rights, and also your response process for them. You have to, under the law, you have to provide a secure and reliable means for consumers to exercise these rights. And so really, it's just a matter of closing the gap between what the processes you already have in place for the other privacy laws and and these rights that are granted under My Health, My Data. And then I also want to call your attention to the right to non-discrimination under the law. So the right to non-discrimination under this act is broad, such that certain types of activities may inadvertently result in discrimination. For example, if you receive a deletion request from a consumer and in response you delete all of their data from your systems, including their rewards data, that may have a discriminatory effect on the consumer because the outcome is that the consumer is missing out on the benefit of their earned rewards points from the program. So for instance, they may not be receiving the discounts that they earned by virtue of that data having been deleted. Unlike the Colorado Privacy Act, which has allowances for instances when a consumer submits a deletion request that allows companies to provide differential pricing or quality of goods or services. My Health, My Data doesn't have that. And so really, when you're honoring these rights, it's really important to think about your desire to honor the consumer's requests and also make sure that you're balancing the sometimes competing outcomes that may result from honoring each of these requests.
Yeah, and I think to kind of dig in on that discrimination point and issue, it's really boiled down like, most of you that are familiar with privacy concepts are well familiar now that like, discrimination in the privacy sense effectively means like suffering a detriment as a result of exercising or not exercising a right. So, and when we looked at like the private right of action under the law that does not have statutory damages that requires proof of actual damages, I think it seems like the discrimination issue, like Giselle's example, like, over deletion of data, you're not able to use your points or you can't access the service anymore. That certainly seems like an area ripe for, the increased possibility of proving actual damages. So I think something, certainly worth paying attention to. Move on to the next slide. Sorry for jumping in.
Thanks, Kyle.
No worries. All right, so consent and authorization. I'm just going to set the stage with this, foundational definitions on collect, share, sell, consent. Kyle will dig into a little bit. I, want to say right here is that, My Health, My Data is really imposing some extensive onerous consent requirements, requiring affirmative opt-in consent for the collection, use and disclosure for processing of consumer health data and that's, beyond what is necessary to provide a product or service that's being requested by the consumer. So it'll be really important for organizations to understand how that's working and making sure that if it's not in relation to the product or the service that's being requested, you're going to have that mechanism for consent fully expanded and operationalized within your organization. In addition, the authorization or the consent to sell is going to require a valid authorization. So there's a heightened level of affirmative consent here that must be separate from, any other consent. And with that authorization for sell, how many, what is it covering, what the purpose is, who those recipients are, how are you treating your advertising information here is going to be really important. And those requirements, like I mentioned before, are very prescriptive, but I'll let Kyle jump in to really, start talking through what those key terms are.
Yeah, thank you. Yeah, so that was a great introduction. And I think let's dive a little bit further into some of the key terms we have to understand to talk about consent authorization. So I think Bull already previewed this earlier, how broad the definition of collect is. If you see that bold red text at the end, the catch-all is, or otherwise process. So collect effectively means anything. I think if you parse the statute a bit, it means any processing minus sharing or selling. I won't get into the technical minutia of that, but if you're really a nerd like me, you want to dive in and discuss that, happy to. Share, this is not to be confused with share from the CCPA, CPRA, that's limited to advertising context. Share under My Health, My Data is rather extremely broad and effectively covers all disclosures, makings available, and so on of consumer health data in any context where consideration is not necessarily present. And so think of like disclosure of data to a government or to an affiliate, a non-commercial context where there's no consideration. Then looking at sale, another extremely broad definition, the exchange of consumer health data for monetary or other valuable consideration. So as many of you will know, fellow privacy nerds, the consideration aspect of the definition is identical to the CCPA. Under the CCPA, I think in view of Sephora, consideration seemingly should be presumed in any commercial context now. I think after Sephora, under the CCPA, the argument that consideration is not present in context where one party exchanges data in return for a benefit, such as like providing advertising services. I think that argument, no consideration, is probably moot. That's assuming the party receiving the data is not a service provider, of course. But I think whether this consideration provision will be construed the same under My Health, My Data, I think it's going to be up for significant debate. And regulators and plaintiffs' attorneys, however, are going to look to the CCPA's interpretation as at least persuasive. Couple of quick notes. Disclosure to processors are not a share or a sale. I think we can move on to the next slide. So let's talk through the requirements for consent and authorizations at a high level. I'm going to talk a lot about what the law says, just as sort of a disclaimer. I think as we dive in further, the first time I read this law, it was like jaw dropping, how shocking, how draconian it is from a consent and authorization perspective. And so, I think you may have similar reactions, like this may not be possible or desirable from a business perspective or technical perspective. So just don't shoot the messenger just yet. I'm going to talk about what the requirements are, because we've got to know what those are in order to advise our clients on how to make risk-based business decisions. So I think it's easiest approach is to talk about the first three bullets together. I think the first concept is that separate consents are required for each, quote, specified purpose of collection. And separate consents must be obtained for collection and sharing separately. But you do not need to get consent for purposes that are necessary to provide product or service requested by the consumer. So, I mean, the sort of immediate reaction reading these requirements is like, how many consents are we going to have to get? Think about your general privacy policy and the way you describe your processing purposes. At least for most companies, like there's a purpose that says, we process your data for providing our products and services. What about the other 10, 15, or 20 purposes that you have in your privacy policy? Are those necessary to provide the product or service, or are you going to have to get consent for those? Or are you going to have to maybe think about, how those fit in and, the interplay between your consumer health data strategy and your general privacy policy. Think about purposes like insurance, research and development, and so on. Like, are those necessary to provide the product or service? I think advertising seems like advertising marketing, like maybe hard to fit under that, but like what about circumstances where the consumer has agreed to a value exchange or like a financial incentive, like a free or reduced cost subscription in exchange for being advertised to? Like, is that use of data necessary to provide the product or service? I think this is sort of just food for thought, just throwing things out there. This is going to be something I think you're going to have to spend a lot of time on considering. I think back to the first bullet, the specified purpose requirement would seem to require, a dozen consents, one for each. It's not necessary. I think there are some drafting inconsistencies in the law where, they use purpose and purposes, plural, interchangeably, where I think you can kind of hang your hat and say, well, there might be some wiggle room here to say purpose means purposes, because they don't use it consistently. I think there is some nuance to that you'd have to consider. I think finally, the other thing we'll focus on is there must be separate consent for collection, separate consent for sharing. I've seen some arguments that since collection equals broadly processing, you can bundle the collection and sharing consents for the same purposes. I don't think that's right because of there's a statutory interpretation nerding out. I think it reads certain provisions out of the law, not permissible. Anyway, I think there could be ways to bundle them, but it's very nuanced, and but something to consider. Where these are going to be very obtrusive consents. We did kind of jump ahead, but I think you're going to have to consider, when you're consent versus authorizations, like what's a share versus what's a sale. And so sale authorizations, as we'll see in a second, very long, very obstructive to user flow. It's going to be hard to get authorizations or even the consents. We're going to have to consider these other requirements, like to the extent there are sales, you're getting authorizations, they've got to be separate from the consent for collection and sharing. Next slide, please. So here's a definition for consent on the left, kind of color coded it. Should look pretty familiar to anybody who's dealt with GDPR or other laws. I think it's very effectively consistent with GDPR, the Colorado Privacy Act. I think these terms that I've sort of pulled out and color coded, they're not defined under My Health, My Data, though they are informed by certain provisions. I think regulators and plaintiffs' lawyers are going to look to other legal schemes and consent standards to define what these terms mean. I think you should too. You should look to the, like the EDPB guidance for, how consent standards are applied in Europe and the definitions of different terms under the Colorado Privacy Act to inform, what consent really means and what you're going to do in that regard. I think just follow it. Next slide, please. The, sort of following the color coding from the prior slide, like what do some of these mean? Certainly, like kind of highlighting the point that Giselle raised before of discrimination. Freely given consent. If you're requiring somebody consent to collection and sharing of consumer health data as part of providing a service, that's not freely given consent. It's also likely discrimination. One other question that comes up a lot is, how long is the consent request going to have to be? I think if you look at this beige box below, informed consent, you look at some of those standards, some of the consent language can be provided in what I'd say is a first layer, like on the user flow right there, provide more information in a link. Certainly there is some nuance to that. I think there are requirements in Colorado that are very prescriptive you'd have to look at too. But I think, the consent, you have some room to work with your business and provide them advice on what the consent is going to look like based on the standard. Move on to the next slide, please.
All right, I'm going to jump in really quickly because I know we're running short on time. But, valid authorization, as you see enumerated on this slide, there are significant requirements. There's, just looking at them, they're onerous. But, there's a lot that you have to capture in order to have valid authorization for the sale of consumer health data. You're going to obviously need the contact details of the seller and the recipient, description, the statement that's really describing, the provision of those goods. Number 8 is important here because, that expiration date, it expires within 1 year or within that year, so within a year. So you'll need to make sure that, your staff is also monitoring the sale that you have of consumer health data and making sure that it's being deleted upon its expiration or you're getting new valid authorization. And, Kyle mentioned it before, it may be difficult for some organizations to have that implemented. And so it's really going to be important for that organization to know what those requirements are ahead of the time. And that's why, we're doing this presentation. But I'll take it back over to Kyle to wrap us up.
Yeah, I mean, I think the only last thing on that prior slide is like, imagine that in like a cookies digital advertising context. It's already hard enough to get consent from just like a simple cookie banner, but if those implicate sale and like look at all the stuff that has to be disclosed, it seems very challenging. But we can move on to the next slide. I think really kind of recap like and sort of sum up where to start. Figuring out, what consumer health data does your company collect, and like, don't just think about the directly from consumers. The data you collect, what's collected by cookies and pixels, what processors are doing on your behalf, what kind of stuff are you doing internally to create and collect it. I think one sort of point to highlight, sort of towards the bottom of the list, is, as of the effective date of the law, if you have consumer health data already on your systems and your servers, you're processing it. As of the effective date of the law, and you need consent for that. So think about that. How broad the law is, how broad collect is, how broad consumer health data is. Also have to look into the sale and share issue. But we can jump onto the next slide. I think talking about communicating the litigation and enforcement risk with a different sort of calculus with the private right of action. The difficulty of deciding on a compliance approach based on how broad the definition of consumer is. It's not just somebody who's in Washington, but somebody whose data is collected in Washington. It's quite difficult to parse out that data, and probably is impossible for most organizations to figure out if someone's data has been collected in Washington in a transitory period while they visited the state. Certainly we talked about number 3. I think we can move on to the next slide. Communicating and assessing the ability to operationalize requirements, I think early and often is really important. I know like from a UX perspective, like even adding like a link or like 2 words can be extremely controversial. And so, I think recognizing that doing those things can have a revenue impact or maybe difficult from a technical consideration perspective. Communicating these requirements and discussing them with your stakeholders early and often, making sure people are trained to receive and operationalize, consumer requests, make sure your staff understands the requirements. I think really sitting down and rolling up your sleeves with stakeholders at this stage, we're 6 months out effectively from effectiveness. Scoping out the project is the best first step at this point. With that, I know we're at time. Thank you for everybody for attending today. I know we have some questions in the Q&A box we weren't able to get to. We can follow up with you separately, but thank you everyone. Thanks Giselle and Bola, and everyone have a nice day.